Supreme Court in the matter of the State of Assam versus Arabinda RABHA quashed the judgments and orders of the High Court. It allowed the civil appeal and granted liberty to appellants to take forward the process of filling up 104 constables in the AFPF in accordance with law by publishing fresh advertisement. Supreme Court said it would be desirable if rules are framed for the purpose of recruitment and such rules are uniformly applied to all and sundry so as to preempt any allegation of bias or arbitrariness. Even if rules are not framed, the selection process may be taken forward in terms of administrative instructions, which in any case should be placed in the public domain. The respondents, if they choose to apply in pursuance of such advertisement, shall be considered for appointment waiving their age bar as well as waiving insignificant minor deficiencies in physical measurement as well as insignificant requirements of the PET, considering that almost a decade has passed since the earlier process was initiated. This concession is granted in exercise of the power of Supreme Court conferred by Article 142 of the Constitution. In addition, it shall be open to the PCCF to grant such further relaxation to respondents as deemed fit and proper. A process of recruitment was set in motion by the Office of Principal Chief Conservator of Forest and Head of Forest Force Assam, Government of Assam, by issuing an advertisement dated 23rd July 2014 to fill up 104 posts of constables in the Assam Forest Protection Force. Process of selection was conducted in May 2016. The respondents who had applied pursuant to advertisement participated in the process. They qualified in the physical efficiency test, whereafter they were interviewed. It was claimed by the respondents that select list prepared by Central Selection Committee, headed by then PCCF, contained names of candidates found prima facie fit for selection and appointment as constables in the AFPF, and that such list, wherein names figured, had been submitted to government for approval. In May 2016 itself, there was a change in political regime of Assam pursuant to the elections held to the Assam Legislative Assembly. On 4 July 2016, incumbent PCCF submitted note to the government highlighting serious anomalies that had crept in the selection process. Based on such note of PCCF but without conducting any inquiry as alleged by the respondents, government approved cancellation of the select list via the order of Secretary to the Government of Assam Environment and Forest Department dated 18 July 2016. The sole reason assigned for such cancellation was that the process had been conducted in violation of reservation policy as well as judgment of the Supreme Court as suggested by PCCO. The broad question of law arising for decision in light of judgments and orders of High Court was whether the High Court was justified in its interference with decision to cancel the select list and to require the process to be carried forward in the manner directed by it. It had been argued that by dint of mere impanelment or enlistment of an aspirant's name for filling up a public post, no right accrues in favor of such an aspirant to move the court for redress. We do not consider, court said, that an impaneled or a selected candidate has absolutely no right to move the writ court. We are conscious of the line of decisions of the court and have noted some of them here which lay down the law that mere impanelment or enlistment does not result in accrual of any indefeasible right in favor of such impaneled candidate, as well as the law that the employer may in its wisdom either decide to cancel the select list or not carry on process further resulting in the notified advertised vacancy or vacancies not being filled up pursuant to selection process which has been conducted. What it means is that an empaneled or a selected candidate can claim no right of appointment if the state has cogent and germane grounds for not making the appointment. However, at the same time, it is also law that appointing authority cannot ignore select panel or decline to make the appointment on its whims. Shankarsan Das case cautions that state has no license to act in an arbitrary manner. In R.S. Mittal versus Union of India, coordinate bench held that when a person has been selected by selection board and there is vacancy which can be offered to him keeping in view his merit position, then ordinarily there is no justification to ignore him for appointment, and that there has to be a justifiable reason to decline to appoint a person who is on the select panel. The position in law finds reiteration in decision of recent origin in Dinesh Kumar Kashyap versus Southeast Central Railway, where the majority held that employer must give cogent reasons for not appointing selected candidates. Court stated that any decision taken not to appoint despite there being vacancies and valid select lists obviously is in nature of a policy decision. It has to be borne in mind that securing public employment is the dream of many who put their heart and soul to prepare for it. Nowadays, aspirants take rigorous study sessions as well as training modules to equip themselves, which also comes at a heavy cost. That apart, since every process of recruitment necessarily involves substantial expenses which are borne from public exchequer, and at the same time, aspirants for the post who, as per their own estimation, have performed sufficiently well and therefore stand a good chance of being appointed upon figuring in the list, cherish fond hopes of a bright and secure future. The law is clear that a policy decision not to carry the process forward must be taken bona fide, and there has to be a justifiable reason if the process is abandoned midway. And such decision must not suffer from the vice of arbitrariness or the whims of the decision maker. This acts as a check on the employer's power, deciding against not making any appointment from the select list despite availability of vacancy on the advertised or the notified public post. A writ court may, upon reaching the requisite satisfaction, intervene in such manner and make such directions as the facts and circumstances warrant. Court said that we therefore do not find it acceptable that the aspirants, not having an indefeasible or vested right of appointment, do not also have the right to question any decision adverse to their interests affecting achievement of their goals to secure public employment. Whether and to what extent any relief should be granted must depend on the facts of each case.